evidences before this court draw near, and contention you will be heard. In God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to another session of the oral argument at the 5th District Court of Appeal here in Daytona Beach. It's Tuesday, September 16, 2025. As our marshal just announced, I am Brian Lambert. I'm one of the judges here, and I will be presiding over the oral argument this morning. We have just one oral argument this morning. We had 3 on the docket initially. The first case settled and they dismissed, and the third case got continued to Thursday for scheduling purposes for one of the counsel. So we have just one case today. Let me introduce the panel seated this morning. To my right, to your left, is Judge Joseph Boatwright, and to my left, your right, we are pleased to have the Honorable Meredith Karbula. She is Associate Judge. She is a Circuit Judge up in Duval County, the 4th Circuit. Does good work with us. We review a lot of her cases. She's on a felony docket now up there. So we see she does a lot of good work up in the Circuit Court, and we're happy to have her with us. It's our first Associate Judge in a number of years since before COVID. We've now gotten the green light to have Associate Judges sit with us again. So we're pleased to have Judge Karbula with us today. We have one case. It is 24-1896, Cynthia Taylor versus Southeast Georgia Acquisitions, LLC, St. John's Law Group, PA, Douglas Burnett, Gulfstream Design Group, LLC. Mr. Latte, is he still involved in the case? I know that some of the defendants settled up. I know we have a list of a number of them, but all right, so what we're going to do, since there's a cross appeal pending, you'll see on the clocks we've given you 30 minutes instead of the 20 minutes. What we will do is, typically the default is 5 minutes for rebuttal if you want to do that. If you want a different amount of time, let me know, and the marshal will adjust the clock accordingly. When you get into your, quote, rebuttal time, you will see the yellow light go on. You can continue on as long as you want. At some point, you get the aggregate of 30 minutes, so if for some reason you use all 30 minutes in your initial argument, okay, sirrah, that's the way it goes. As to the appellees, since there's a number of you there, I will leave it to your discretion as to how you want to divide up your time. We will also set 5 minutes for the default time for the rebuttal on the cross reply. Again, if you want to use a different amount of time or preset a different amount of time, let me know, and the marshal will adjust the clock accordingly. And again, the yellow light will go off when you're into your rebuttal time on the cross appeal. Any questions? We're good? Counsel, you ready?
Yes, Marshal, if I could get 7 minutes for rebuttal time, and that's just because of the cross appeal, I figure.
Fair enough. All right, counsel, if you're ready, you may proceed.
May it please the court.
Sir.
My name is Tim Taylor. I represent the appellant, Cynthia Taylor. We are here on appeal from a jury trial in the underlying matter, and it is from very discrete issues from that jury trial this appeal arises. First, the jury found that Southeast Georgia Acquisitions breached a land sales contract with the owner appellant, Taylor. The jury found that Southeast Georgia Acquisitions caused $150,000 in damages to Taylor resulting from the breach. However, the jury then additionally found that Taylor could have mitigated her damages and reduced the verdict to 0. The jury also found that the land use attorneys for the PUD, St. John's Law Group and Douglas Burnett, did not owe a fiduciary duty to the landowner Taylor. And the jury also found that the professional engineers for the PUD, Gulfstream Design Group, and Matthew Lottie did not owe a fiduciary duty to the landowner. It is from these findings of fiduciary duty and mitigation of damages from which this appeal is taken. And so basically, Your Honors, the summary of the argument is point 1. The trial court erred as a matter of law by failing to direct a verdict for Taylor on whether a fiduciary relationship existed with the professional appellees. That's both the land use attorneys and the design professionals. As a matter of law, agency creates a fiduciary relationship, and the evidence undisputedly demonstrated that Taylor granted all 4 professional appellees agency authority to act on her behalf with respect to any and all applications related to her property. The court should reverse and remand for new trial on Taylor's claims for breach of fiduciary duty, at which the jury should be instructed that the professional appellees owed Taylor fiduciary duties as a matter of law.
So, sir, the agent is subject to the principal's control, correct?
That is correct, Your Honor. And
So was your client ever subject to Mr. Burnett's or were they ever subject to your client's control?
yes, absolutely. And that's reflected in the record because what occurred early on is these were 2 land sale contracts. The first being the northern parcel of 60 acres. In that land sale contract, they were entitled to pursue a PUD, but could only be a PUD for residential use only and could not have public uses. Once they filed their initial application for the PUD under the first contract, it was discovered that they were seeking a public use, a park, in order to get a density bonus. My client discovered that the PUD had been altered in such a fashion and immediately contacted Mr. Burnett and said, if you do not remove the public park from the PUD, I'm terminating the contract and I'm pulling the PUD. My client had absolute authority as the owner of the property.
Did he do that? Did Mr. Burnett do that?
Well, that's a good point, Judge. So what happened is instead of, apparently the developer really wanted the density bonus. So the developer, through Mr. Burnett, came back to my client and said, Mrs. Taylor, we would like to buy the other parcel of land. Therefore, we'll buy all your property, and therefore, we would like to have full control over the PUD. To which
I guess what I'm asking is where did Ms. Taylor direct them, and then Mr. Burnett or Lottie, as it is, how are you saying that they actually were that she directed them? Because I don't see that. I see them acting on behalf of SGA, but I don't really see them acting on behalf of her, which I think is part of your argument.
Well, the landowner controls the land use entitlements to the property. The landowner is always responsible for the property. The fact that she went under contract with a developer that wanted a PUD on the property to close still required that the landowner file the applications for the land use changes in the PUD. Because of that, the land use owner has to give authority to the land use attorney, land use engineers, so that they can prepare the land use documents for submittal to the county and represent the owner in that process to get the PUD. The fact of the matter is, at any time, Mrs. Taylor had full control to pull the PUD and to terminate these contracts if the PUD was not being sought in conformance with the contract. And that's exactly what happened under the northern parcel, the very first contract. She discovered that they were breaching the contract by pursuing a public use, and she stopped it. And she stopped it, and then in order for them, because they didn't want to terminate the contracts, they said, we'll buy your other parcel. And so if we buy all your parcels, then you should be okay with the public uses or anything else that we put on there. Mrs. Taylor said, well, under one condition, you have to put $2.25 million in escrow before the Board of County Commissioners meeting. Therefore, if you get a PUD granted and you don't close it, I'm left as the landowner stuck with that PUD. At least I have money to mitigate. And the record evidence shows that the developer, through Mr. Burnett, said, no, we don't need to do that. What we'll do is we'll draft an addendum that says we'll make the public park removable by small adjustment.
Isn't that just her negotiating terms with SGA rather than Mr. Burnett and Mr. Lottie being under her control?
Well, they're under her control because they're acting on her behalf. If we look at the owner authorization forms as well as the agent authorization form of Gulfstream, it says agent authorization. So if we look at these forms, the county requires these forms so that these individuals, whoever the owner gives authorization to, can act on our behalf, which includes submitting, according to this,
Was
any
that
and all...
Lottie form ever submitted to the county?
I'm sorry, Your Honor, I did not get your
I
question.
said, was the Gulfstream, was that form ever submitted to the county?
As to Gulfstream, it says that this form is for, it says, to act as...
Both of these were submitted to the county. My question was the Gulfstream, I think the appellee argued that it was never submitted to the county. Was it submitted to the county?
I was referring to both these forms, the owner authorization forms, where there was two.
That's what I'm referring to.
And then the agent authorization form, it allows them to act as their agent with respect to all regulatory agencies, FDOT, FDEP, as well as any and all St. Johns County departments. So it specifically includes St. Johns County on the agent authorization form. And the point being is, because they have to, only the landowner is stuck with the land use entitlements. And so the landowner has to give this agency authority to these individuals so that they can submit these documents that change the land use on our property. And the fact of the matter is, everybody who has testified has stated emphatically that the St. Johns County Land Use Development Code controlled this PUD. And in fact, the St. Johns Land Development Code has agent and defined, means any person with valid authority provided by the owner as evidenced by a notarized document authorizing the agent to represent the owner and acting on behalf of the owner of the land, seeking a land use change, rezoning, appeal, or any other activity set forth in this code. That's the definition of agent. St. John's Law Group and Mr. Burnett's own expert testified and conceded that the plain language of the county's definition of agent falls squarely within the legal documents that the county provided.
What's their argument, what's your opponent's argument as to why they're not agents? If you have this form that says agent authorization, and therefore they must be, it's got the word agent in it, and so what are they telling you or telling us today as to why it's a factual dispute?
The appellee's point of contention of this is because Mrs. Taylor did not retain and pay for their services. They had no duty and loyalties to Mrs. Taylor. But that obviously overlooks the fact that in order for them to perform any of their duties for this PUD, they need her agent authorization so that they can represent her to change her land entitlements. And in fact, that's what they did. I'm not saying that they can't be paid by other people and they can't work for other people, but when they get these forms signed and they're agents for the landowner and they're affecting property rights, and they're considered agents under the Land Development Code, they owe, by definition, a fiduciary duty to that landowner. And in fact, if we look at just even the most recent Black's Law Dictionary definition of agency, it clearly says, and I had to submit this as a supplemental filing on September 4th, but it's a fiduciary relationship that arises when one person manifests assent to another that the agent will act on the principal's behalf. And that's the whole point of this proceeding. Because this is an issue of de novo, when you look at these documents, what do these documents mean and what do they plainly state on their face? And they're agent authorization forms. And and even though the county's testified that these are required for Mr. Burnett to pursue the PUD, and even though Mr. Diebenauer has testified, his expert, that they satisfy the agent requirement, even if we were overlook the plain language of these documents, and even if this court didn't want to find as a matter of law that the agency existed for purposes of fiduciary duty, this leads us to point 2 in the alternative of our appeal. We also specifically requested that the court give an agency instruction, because these are legal principles that lay jurors cannot understand.
Counsel, Ms. Taylor clearly knew that Mr. Burnett had represented the buyer, right?
No, Your Honor. When you say Mrs. Taylor clearly knew he represented the buyer, that's not my understanding of the testimony. The testimony was Mr. Burnett had previously represented Mrs. Taylor for land use issues on her property, and then told her when she was selling her property that she would represent her in the PUD process. So Mrs. Taylor had no understanding whatsoever of the contractual arrangements that Mr. Burnett had with Southeast Georgia Acquisition. And that's a problem in the trial, because in the trial it was discovered that the contractual arrangement that Mr. Burnett had with Southeast Georgia Acquisition was based on a success fee of buildable units achieved under the PUD. That's why they pushed the public use in the public park to get a density bonus so they can increase the number of buildable units, and he was getting $1,000 per every buildable unit he got over 120. So therefore, under the northern parcel alone, he was getting an extra 15 units, which increased his fee, unbeknownst to my client, by $15,000. There was self-dealing going on, and that's the problem with this. There's an agency and a fiduciary relationship with the landowner, so you do no harm to their property, but on the other hand, he's getting paid by a developer to pursue that PUD, and unbeknownst to the landowner, there is a financial incentive to increase the buildable units under that PUD, which in this case resulted in a public park encumbering our property when they walked away.
But isn't it, I mean, the representation, getting the PUD would make the deal go through, right? I mean, in other words, it was a win-win, because if the PUD went through, then they would close on the contract. That was this sort of the idea. So the getting the PUD was the incentive for the buyer to close. So aren't their interests sort of aligned at that point? Getting the PUD was the whole raison d'etre of the
Certainly.
proceedings.
Your Honor, I would agree with you that the PUD was a condition for closing for the developer. But that you've got to look at that, but there were still restrictions in the contract by what you could do in getting that PUD. And the restrictions in the contract would not allow them to put a PUD on our property with a public use, including a public park dedication. Also said no industrial, no commercial. It was residential only. So that developer was constrained by the terms of the contract with the landowner. The land use attorneys knew that contract very well. They happened to also draft the addendum related to the public park. They knew what the constraints were under that, and they breached that contract knowingly to the detriment of the landowner by following the directions of the developer. And therein lies the conflict of interest. And part of the appellee's response to this is, well, we could never have represented the landowner because there would be a conflict of interest. Well, there didn't have to be a conflict of interest. That's the whole point. Nobody knew that there was going to be a financial incentive to increase buildable lots by the land use attorney. And even if there were, all the land use attorney had to do was make known that conflict of interest to the landowner and let the landowner know what they were doing with their PUD, and the landowner could have taken action to withdraw the PUD and terminate the contract. This is not some situation where just because you're getting paid by another person, you owe no duties to the landowner whose property you're affecting. And that's why we have these agency authorization forms, to create that duty, to do no harm, and owe honesty and loyalty to that individual. And so, because it is a legal concept of agency, it's not just your garden variety fiduciary duty. We had also requested the court, and this is part 2 of the appeal and the alternative, that we get an agency jury instruction. The jurors needed to understand that when there's an agency relationship, there is a fiduciary duty as a matter of law. Without that knowledge, they had no concept and understanding of what these forms actually meant. All they knew is that there may or may not have been a fiduciary duty, and these appellees could go argue all day long that I had no contract with the landowner. I was getting paid by the developer. I didn't owe the landowner any duties or responsibilities because agency wasn't explained to them. Had the jurors
Let me ask counsel, did the jury ask any questions during their deliberations about the definition of agency or anything related to the agency term?
No, Your Honor, because, as part of the case law points out...
Well, because you were arguing that to them about agency, right?
Well, no, because the court refused to give the agency instruction and stated on the record that the fiduciary instruction was sufficient. I was not going to go in front of the jury and start giving new law on areas of agency that the court had already rejected on my request for a jury instruction. I probably would have gotten an objection for mistrial, probably granted, because you can't bring in new concepts when the court has said the trial judge has said, I'm not going to inform the jurors of these concepts of agency, and as a matter of law, does that create fiduciary duty? We get
You're
into legal...
concerned that the judge, at the day 9 of a trial, would declare a mistrial and have to do it over?
Pardon me, Judge?
You think the judge would have declared a mistrial if you used the word agency during the course of closing and had to redo a 9-day trial?
I don't believe if I just mentioned agency, but I believe if I said agency creates a fiduciary duty as a matter of law, and therefore you must find a fiduciary duty exists. I'm walking a fine line about trying to instruct the jurors about what the law is in this state versus what the court's willing to inform them. And so that's why, given the fact that the standard jury instruction for fiduciary duty does not even mention agency, when we look at what the standard is or whether your special instruction is warranted, it says all parties are entitled to jury instructions on their theory of the case, even when the defendant offers evidence controverting that theory where the evidence substantially supports the plaintiff's theory. Mrs. Taylor has agent authorization forms and county owner authorization forms that state that these individuals will act on her behalf. And the law goes on to say, a party's ability to make an argument to the jury does not substitute the need for a complementary instruction not covered in the standard instruction. Leaving it to the party's attorney to explain to the jury in closing arguments what legal principles apply is an inadequate substitute for an accurate, relevant, and complementary instruction that contains legal principles not covered in the standard.
Well, the jury was tasked on the verdict form with assessing or determining whether there were fiduciary duties owed by various defendants to your client, and there was an instruction given on fiduciary duty, and the fact that maybe agency would be a good instruction, at least on your side, how does that, isn't it an abuse of discretion standard, and how is that an abuse of discretion if the fiduciary duty is described in the instruction that was given?
Sure. And I'll quote, a trial court abuses its discretion when it fails to give a proposed instruction that is, 1, an accurate statement of the law, 2, supported by the facts of the case, and 3, necessary for the jury to properly resolve the issues, so long as the subject of the proposed instruction is not covered in other instructions given to the jury and the failure to instruct is shown to be prejudicial. And that's my point. Just a garden variety breach of fiduciary duty instruction, which is a factual issue based upon most relationships, does not inform the jurors that in an agency relationship there is a fiduciary duty as a matter of law.
But the jury wasn't tasked with finding whether there was an agency. I'm looking at the verdict form, and it doesn't say that.
I agree, Your Honor. And that's why I moved for a directed verdict, because agency was put front and center. And when that was denied, I asked for an agency instruction that said, look, if jurors, if you find that if you determine that there was an agency relationship between the parties, then as a matter of law, there's a fiduciary duty. The problem is we've got legal principles that we're trying to give over to lay jurors to address this issue. And the fact of the matter is that the standard instruction is based upon a relationship that is not a legal one that comprises, by law, a fiduciary relationship. Agency is. And because agency is a concept as a matter of law that gives a fiduciary duty, the jurors needed to understand that so they could understand what these documents meant. What does it mean when you give somebody the authority to act on your behalf and change the land use entitlements to your property? As we all know, property is distinct and personal to everybody. To give that over to another person.
Wouldn't that person have a fiduciary duty to the landowner?
Absolutely.
So when they were the jury was instructed about fiduciary duties, and they rendered their verdict as they saw fit.
Judge, I will not disagree that they got a standard instruction of fiduciary duty. However, they did not get the complementary instruction, a specific instruction on agency, which takes us from a fact issue to a matter of law. And it's a separate legal principle. There are many kinds of fiduciary relationships out there. And if the standard instruction was always sufficient, we would never have special instructions. Therefore, the court needs to look to see whether a special instruction...
I think the issue, though, with us, though, is, okay, the judge could have given it, and then we would have the same discussion, I guess, with your opponents, saying, well, why was that an abuse of discretion to give it? And I guess the question is, why isn't it, how is there a miscarriage of justice being done here by the failure to exercise the discretion to give that instruction as requested?
Well, and it's because agency is not found anywhere in the standard instruction for breach of fiduciary duty. It's because that instruction lacks this legal principle and concept, which by law creates a fiduciary relationship, is why it's insufficient for this particular issue, which is of agency. And so, even if the court doesn't find as a matter of law that these documents create an agency relationship giving rise to a fiduciary duty, certainly these documents on their face agent authorization, I'll act as your agent, we'll act on your behalf, should provide enough evidence to give to the jurors so that they can understand this concept of agency.
Mr. Taylor, I'm interested in the damages issue. So before you run out of time, I was hoping that you might address the offset of the verdict.
Yes, thank you, Your Honor. Well, as I've said in my opening, there was a finding that Southeast Georgia Acquisition breached these contracts. There was a finding that they caused damage. And then there was a finding that post-breach, that somehow Mrs. Taylor failed to mitigate her damages, resulting in a 0 verdict. Now, under Section 768.74 of the Florida statutes that lays out the criteria for determining whether a jury's award was adequate, but we can jump squarely, looking at that, whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. If we look at just a briefing in this case, nobody challenges the $150,000 in damages caused by the Southeast Georgia Acquisition breach. It appears that everybody can deduce that the jurors accepted D.R. Horton's contract at $4.75 million. You know, they reduced that from the $5 million, got $250,000, and it was offset by the $100,000 of deposits. Now, the problem is, after that, there is...
Is that the amount of damages you claim your client was entitled to, the $250,000?
No. We had several theories, damage models, ranging from the $4 million that Mr. Bean bought the company through a straw buyer of Big Island, deducted from the $5 million, so there's $1 million there. We had an expert come in and says $1.2 million. For whatever reason, the jurors decided that D.R. Horton's contract was going to be the measure of the damages, and it was going to be $150,000. But at the end of the day, if we look at the briefing, nobody challenges the $150,000. What is being challenged, and the record's devoid of, is that there was a failure to mitigate. In fact, the record evidence is that my client did everything possible to mitigate her damages. She retained land use attorneys.
It's up, you're into your rebuttal time, but go ahead if you want.
Thank you, Judge. She spent close to $10,000 on land use attorneys, land planners, land engineers trying to fix this PUD post-brief. She was a woman in her 60s, living on Social Security, and obviously couldn't bear the financial burden of trying to go through a major modification to remove that park. Unfortunately, she had to sell, was the only way to mitigate her damages. The appellees raise, in defense of our appeal, that the evidence shows that she could have granted an extension of time to close on the project, close on the contracts, or she should never have sued and published the damage to her property. Neither one of those carry any weight. We have cited, first off, we have shown that through the case of Seabreeze versus Restaurant Inc. versus Palm Gardner 639 Southern 2nd 69, that the seller does not breach any duties by enforcing time is of the essence in a purchase and sale agreement. She had every right, after 12 months of having her property off the market, to demand that the closing take place. They refused. She was not required to give them an extension time. That's not a legal obligation that she had to give. Moreover, what would an extension of time given? We know who purchased the property, Stephen Bean, the owner of Southeast Georgia Acquisitions, and he only would pay $4 million a year later. The extension of time wasn't going to do anybody any good. In fact, what they testified is they wanted to sue the county in the name of my client, the appellant, to try to grandfather in the old FEMA maps, which became a life safety issue based upon the testimony of Mr. Schock, the county's representative in control of the FEMA flood map. So my client was not going to participate in that. My client shouldn't have to participate in that on life safety issues. So, and the other issue, they said that she filed suit to enforce her rights under the contract, which disparaged her property. That is not a mitigation. She did everything she could to mitigate, and they can't point to anything that would satisfy what she could have done under reasonable circumstances. They're just basically saying, give me an extension of time, or she filed suit. And frankly, that just doesn't satisfy the requirements to support by the manifest weight of the evidence. Thank you, Your Honor. Well, with that, Your Honors, I will reserve the remaining time for rebuttal. Thank you.
3:49 left. Counsel?
Good morning, Your Honors. My name's Al Frivola on behalf of Southeast Georgia Acquisitions, and may it please the Court.
Yes, sir.
Can you address my first issue that I asked counsel? It seemed to me, and you can correct me if you think I'm wrong, that the sole basis for a reduction of the verdict for the plaintiff from 150 to 0 and the failure to mitigate damages was her refusal to allow your client an additional 30 days to explore the flood, what effect the flood zone redesignation would have on their ability to build units. So what evidence in the record supports the notion that with that additional 30 days, then your client would have actually closed on the property?
Yeah, I can do that, and we'll do that now. So, again, 9 days of trial, 6 weeks of litigation. We believe the jury got it right, that Ms. Taylor had no claims, valid claims against SGA's professionals, and in the end of the day, no recoverable damages against SGA. The judge, Judge Maltz, when he considered the motion that Mr. Taylor is appealing the order from, found that the argument he made was entirely without merit. And he pointed specifically to the manner in which the damages were calculated or could have been calculated. I respectfully disagree with Mr. Taylor that this was something that we all agreed on. We agreed that that was a reasonable method that they could have determined the damages, but we're not conceding those were the damages. That's just what the jury found. And the numbers all support that. The issues with respect to the support of the damages and then the offset are twofold. And although the judge in his ruling focused on the issues that you're talking about, which are important, because even in their brief, Mr. Taylor admits, this is on page 31 of his initial brief, that Mr. Burnett, our lawyer, believed that the engineering problems could have been resolved had more time been given, number one. Number two, he also acknowledged that Mr. Lottie believed he could have solved the engineering problems. Number three, Ms. Taylor herself had requested a 30-day extension of time to move out of the property. And so giving us the additional 30 days that we had requested for or not is wholly unreasonable. Regardless of time is of the essence, there's still the obligation to act reasonably under the circumstances. Her realtor, Clay C., said he didn't even know about the request, and had he known about it, he would have advised her to take it because it would have been a reasonable request. Mr. Schock, the FEMA flood map advisor for the county, testified that he'd been challenged before on his decisions, and had there been a challenge here, he may very well have changed his mind. Jimmy Johns, who was the expert for Mr. Lottie, the engineering expert, who also happened to be one of the county commissioners who approved this PUD with the designs that were presented at the time, he testified that the information-only comments that Mr. Schock had made were not relevant to a design professional standards, and that the civil engineering designs should be made according to the flood maps that are in place when the documents are drafted and approved, which again, they were. There's no dispute about that. The PUD also language granted vested rights to the developer as of the approval. And so at the time, the flood maps that were in effect were the ones that were designed, and there was a good, valid vested rights argument there. So there was certainly enough competent, substantial evidence for the jury to conclude that had that 30 days been granted, there was evidence that we were already asking for reconsideration on this issue, that this issue could have been resolved reasonably, and Mr. Burns, my client representative, testified they would have closed had they been able to resolve these issues. So plenty of evidence for the jury to conclude that the $150,000 offset was appropriate. if you look at the verdict form, just got to find the right page here. The verdict form asked the question specifically, I know it's in here somewhere. Forgive me 1 second. What is the amount of Cynthia Taylor's damages that could have been avoided with reasonable efforts or expenditures made by her? And they said $150,000. Clearly, they're not obligated to go above that, but I think there was ample evidence that she had caused damages in excess of that as well. We briefed the issue that, and on our cross appeal, the argument about whether the public park was optional. We clearly believe it was. This notion that the public park was not optional and was some extensive burden is an issue that even Ms. Taylor didn't believe. She wrote an email in January of 2018, before she filed this lawsuit, acknowledging that the language said it was optional and it would be up to the developer to decide whether to take advantage of the density bonus and build the park. So she had in her mind already this is an optional issue, and then for reasons that were never fully explained, on March 15, 2018, about 5 or 6 days, I believe, before she filed this lawsuit, she writes a letter to the county commission in which she says that the PUD, which gave significant residential development rights to her property, stripped her property of its potential use and left it wholly unmarketable. And in that same letter, she claimed that the PUD devalued her property by $1.5 to $2.5 million. She gave this letter to her realtor, Mr. C., who then testified that he had an obligation to share this with all of the potential buyers that he was presenting the matter to. And we argued to the jury that, and I think it's pretty self-evident, it's wholly unreasonable for somebody to go out who is looking to sell their property and achieve fair market value and achieve best value to publicly declare that their property has been devalued to the tune of $1.5 to $2.5 million. That is what put D.R. Horton in the position of being able to use that against Ms. Taylor when they wrote the email saying, we're going to only give you 4.75 because of the park. And don't forget, D.R. Horton ultimately purchased 120 of the 180 lots that were developed in the community with the public park. So there was more than ample evidence for the jury to say, Ms. Taylor, you didn't act reasonably by giving them the extension so they could work out this flood map issue. And you certainly didn't act reasonably when you then went out and declared to the entire buying world and community that you believe your property is worth $1 million less than it is. You created your own damages. And so for those reasons, we think the jury's verdict was correct and is consistent with the law. If I may, on our cross appeal quickly, the contract was negotiated before the final PUD language came into existence. So we didn't really know at the time that we negotiated the contract exactly what the PUD language would look like. So there was, added into the contract by Mr. Burnett, our lawyer, the provision that requires that the buyer shall make the dedication of the public park optional, so that the seller is not required to have any portion of the property be subject to the public park dedication. That's clear and unambiguous. There is then an exemplary clause after it, not a mandatory clause, but an exemplary clause that says one way that you can achieve this optionality is by including this small adjustment language as opposed to major modification. But when you look at the clear and unambiguous language of the actual PUD, it is clear, when you read it as a whole, that the density bonus and the option to use the density bonus is optional. It even says in section F, under the non-residential development section of the PUD, that there is potentiality for 8 acres of a public park use recreational park, and that if optional density bonus is utilized, then the park needs to be dedicated. Uses the same language. It says it's optional. It's always optional. There's never, the county under no circumstances, reading the clear language of this PUD, could have forced any developer to use the density bonus or dedicate the park. It just was never legally required. And if a developer were to come in and change the plan, because we submitted a 202-unit plan, which did utilize the density bonus, by definition, when they come in and they submit a plan that doesn't utilize the density bonus, as it says clearly in the PUD, they would have to show that they're providing the private recreational facilities that are required under the Land Development Code, which would satisfy the terms of the PUD and eliminate the density bonus. It was always optional on the buyer, and the park was never an encumbrance or never saddled anybody. And in fact, once it became evident, by the time this fight all went to its end, the flood plan maps had been adopted, and there was no ability to build more than 180 units. So it was a moot point anyway. And so we believe that the verdict should have been directed in our favor, but certainly the jury got it right in the sense that even though SGA failed to close, which they had the right to do under the contract, they did not cause her damages, and any damages she suffered were caused by her own failure to act reasonably and her failure to reject her own interpretation of the PUD language, that it was optional, as evidenced by that email that she wrote in January of 2018. Thank you.
Okay.
Good morning. Robert George on behalf of Appalese, Douglas Burnett, and St. John's Law Group. May it please the court.
Sir.
Again, the issues related to my clients are limited to the two issues of the denial of the motion for directed verdict and the denial of the special jury instruction. With respect to the motion for the denial of the motion for directed verdict, I'd just like to note that I think appellant is facing a very stringent burden to demonstrate his right to a motion for directed verdict, especially given the evidence that was presented during trial relating to the issue of agency and in particular control. I think in looking at
So you think it's a question of fact as to whether your client was an agent for Ms. Taylor?
I definitely think there is significant issues of fact, going to whether there was a principal-agent relationship. It is not just a matter of law.
So there, factually, there could be an agency here.
Factually, there could be. We argue that there was not. And in fact, the overwhelming evidence demonstrated that there was no principal-agent relationship between Ms. Taylor and my clients.
But if it's a factual dispute here, then shouldn't he have gotten the special and jury instruction to define what an agency is?
No, I would disagree with that. Again, I think...
I figure you would. Why? I'll rephrase. Why was the judge did not abuse his discretion in doing that?
With respect to the
in
jury
declining
instruction...
to give the instruction.
Well, Your Honor, with respect to the jury instruction, again, Florida law is clear that in issuing a special jury instruction, in addition to a standard jury instruction, the court has to look at three different factors: whether the special instruction was supported by the evidence, whether the standard instruction did not adequately cover the legal theory, and whether the special instruction was correct on the law and did not mislead the jury.
Was it accurate?
I do believe it was accurate, Your Honor.
Okay.
I think
was there evidence then submitted by the plaintiff, Ms. Taylor, that a jury could find that your client was her agent?
Yes, Your Honor. There was evidence presented of that, but again, I think you really have to look at, the court should look at the second factor.
Well, I'm just going down to three prongs. So the first two prongs seem to support giving the instruction. So the third is it necessary to properly resolve the claim? Why wouldn't it have been necessary to to inform the jury what an agency is so they could take that in consideration in determining whether a fiduciary duty was breached?
Because if you look at the second factor in the Cliff Berry versus State case, it's whether the standard instruction did not adequately cover the legal theory. And again, this was a breach of fiduciary duty case.
Does it define or talk about agency in the fiduciary duty instruction?
It gives a very broad and general discussion of the type of relationship that must be present to justify a fiduciary a duty. And that broad general definition would most certainly include a principal-agent relationship. Again, if you think about...
Did they plead agency in their complaint, or principles of agency?
They pled breach of fiduciary duty claim, and there was a very limited reference to agency. I want to say maybe one or two words. Again, in this case, the primary claim against my client was the legal malpractice case. The general arguments from plaintiffs throughout the case and throughout the trial was that there was an attorney-client relationship that existed. And the agency was definitely a secondary argument. The claim that was asserted was a breach of fiduciary claim. And in Florida, many fiduciary duty relationships or obligations are created out of principal-agent relationships.
Could your client have been found not negligent regarding the professional negligence claim, but have found to have breached a fiduciary duty?
I'm sorry, can you repeat that?
I'm trying to figure out how I'm looking at the verdict form. Is Ms. Taylor's claim, was there an attorney-client relationship between St. John and Burnett and Ms. Taylor during the PUD process? If they answered that no, which they did, but then the next question, as to the claim of breach of fiduciary duty, could they have found that that your clients breached a fiduciary duty if there was no finding of an attorney-client relationship?
Yes, Your Honor, they could have.
They could have. What would have been the fiduciary duty outside the attorney-client relationship that owes a fiduciary duty as the attorney to the client?
I think the primary argument was based on an attorney-client
That's what I'm saying. So if they find there's no attorney-client privilege, there's a fiduciary duty as the attorney to the client. And if they find that, if they answer as they did no, how could they then find there's a fiduciary duty breach? What else did he did outside? What else would he have done outside the attorney-client privilege?
I mean, if you looked at, they could have determined that there was some sort of principal-agent relationship outside of an attorney-client relationship. However, that was not what was argued during the trial. Again, in looking at just the principal-agent relationship, even outside of an attorney-client relationship, Florida is very clear, as Your Honor noticed, that control is a very important issue. I think if, under the Goldsmith case that we cited, Florida law is clear that control is an essential element of an agency relationship. And I think the Orlinsky versus Petraka matter or case is especially relevant to this because it states that the principal has to have control over the operative details of the agent's work. And clearly that was not present here. The overwhelming evidence that was presented during trial was that my client was working for SGA, that he was controlled by SGA, and that was from his testimony, from SGA's testimony. It was clear that he was not representing Ms. Taylor in an attorney-client relationship. That was determined through the contracts, the retainer agreements, through the bills that were submitted, through the correspondence. The correspondence included Ms. Taylor's on real estate broker who wrote and referenced that my client was representing SGA. Ms. Taylor's own correspondence to my client said, SGA is lucky to have you. Their introductions during the meetings where my client would introduce SGA as his client and he would introduce Ms. Taylor as the landowner. There was no control here. No control. In fact, Ms. Taylor had contractually relinquished any control over my clients. Again, pursuant to the contract Ms. Taylor entered into with SGA, she contractually allowed SGA to file whatever documents were needed for the PUD.
So as to the first issue, you're saying that there's no error about the denying the directed verdict, about the fiduciary duty, that you believe that there is evidence that your position is necessarily that there wasn't an agency or a fiduciary duty owed, but at the very least, this is a factual dispute that the judge let go to the jury.
At the very least.
At the least, and
At the very least, there's a
therefore, it's no
factual
reversible error on the first issue raised by the appellant.
Correct.
Okay, go ahead.
And again, back to the relationship between Ms. Taylor and my client, there really was no relationship. Again,
What about the owner authorization form? I mean, that appears to show a relationship.
well, it's a relationship based upon a contractual right that SGA had. SGA had the contractual right to pursue the PUD, which they did. SGA, pursuant to the contract that Ms. Taylor entered into with SGA, was responsible for all costs and expenses related to that application. They had to hire the attorneys. They had to hire the other professionals. Ms. Taylor's only obligation was to sign whatever document SGA needed. The fact that she signed that document did not create any type of relationship between her and those professionals, including my clients. It was her contractual obligation to do so because she had contractually given SGA the right to pursue that PUD and those zoning changes. So this wasn't a typical application based upon the contract between Ms. Taylor and SGA. I think the evidence was clear that this form was a standardized boilerplate form that did not allow for any type of explanation of what party was doing what.
It's a standard type of transaction in land development like this?
It is a standard form that cannot be changed, and Mr. Deebenow testified that really the only purpose of this form is for the county just to make sure that that the owner is on notice that changes are being made to their property. It did not create any type of attorney-client or agency relationship between Ms. Taylor and the professionals that SGA had hired. You know, just a couple other issues as it relates to the form and the St. Johns County Land Development Code. There was the definition of agent that was referenced by opposing counsel. I just want to be clear, that's in the St. Johns County Land Development Code. That does in no way creates any type of agency relationship as a matter of law. If you look at that
It
definition.
doesn't preclude us from looking at other law, or we're not bound by the St. Johns County Development Code, are we?
I would think y'all agree that y'all are not bound by the St. Johns County Land Development Code definition, which does not even mention or address the issue of control. Also, an issue is there's a obvious conflict here if there was some type of relationship between my clients and Ms. Taylor. I know that opposing counsel will try to argue that and spin it as that's further evidence of wrongdoing. No, what that is it's further evidence that there's no relationship between Mr. Burnett and Ms. Taylor. And I think while the two issues that are address my client, the jury instruction and the denial of the directed verdict are separate and distinct, there is one crossover. And that's if you look at the proposed jury instruction by Ms. Taylor, it specifically states in there that nor to act for two principals on opposite sides of the same transaction. By the definition of their own proposed jury instruction, it demonstrates how this conflict was there, and there could not be a principal-agent relationship between Ms. Taylor and my client when it was very clear that my client was representing SGA.
Would you agree that their interest, at least in getting the PUD, was aligned?
It was aligned because it was a condition proceeding to closing. And it was also aligned because any type of PUD, I would agree with SGA's counsel, would improve and increase the value of her property. So even if there wasn't a closure on the contract, her property would be worth well more with the PUD than without the PUD. I think in two final issues, then I'll turn it over to my co-counsel. But one, I think while this is not determinative, but it is persuasive, the correspondence between Mr. Taylor and his mother about the fact that he advised her not to sign the authorization form because that would leave her naked, because he did not believe there was any type of basis for a lawsuit or indemnification between SGA and the other professionals and Ms. Taylor. And then finally, with respect to the jury instruction, I think one element that Ms. Taylor has to demonstrate is that she was prejudiced in some way. And I would just like to say that to the extent that the SGA judgment is upheld and there are no damages in this case, there would be no damages with respect to my client or the other professionals. They're the same damages that were sought. To the degree there are no damages, there would be no prejudice. Thank you very much.
All right. Okay. All right, just so we're clear, counsel, you guys, the appellee's side is into their, quote, rebuttal time. There's 4 minutes, 17 seconds left. So whatever amount of that time you use, if you use it all, then there's no rebuttal time on the cross appeal. Now, if at some point if you stop shy of 000, then I guess you would come back up if you want, if you choose. But I'm just laying the groundwork here as to where you guys are with your time.
Thank you, Your Honor.
All right, you can proceed, counsel.
Good morning. My name is Alexander Harn. I'm here on behalf of Apelli Gulf Design Group and Matthew Lottie. Going forward, I'll refer to both of them as Gulfstream. May it please the court.
Yes, sir.
I'll do my best to try not to regurgitate some of the facts and arguments that have already been hashed today. I'll start with point one. Ms. Taylor's directed verdict was correctly denied. Congruent to the court's 2011 ruling in Crucell, 59 Southern Reporter, 3rd version, 1178, Ms. Taylor's directed verdict was properly denied because of clear conflicts of fact fitting for jury determination. SGA and not Taylor retained the services of Gulfstream to effectuate the site plan portion of the PUD. Taylor was never a party to the contract between SGA and Gulfstream, and Taylor was never asked to countersign it. Gulfstream never had a contract with Taylor.
There is a form, though, correct, that on the title of the form says agent authorization, correct?
That is correct, Your Honor, but I'll point
Isn't
to...
that some evidence of an agency, at least evidence of that?
I believe that's some evidence of it, but we deny there's any agency principle involved. Our expert, Mr. Jim Johns, testified that Gulfstream was not contracted with Ms. Taylor. He further testified that the written authorizations required by St. Johns County have no effect other than authorizing engineers and other professionals to submit plans on behalf of the property owner. Mr. Johns further testified that completion of the written authorizations did not create a client relationship. After SGA terminated the contracts, SGA itself terminated Gulfstream, not Ms. Taylor. The judge correctly found that there are significant facts in all aspects of the party's case which require determination by the jury. There's ample support for denial of Taylor's directed verdict, especially as with respect to agency and other considerations therewith. As to point two, the judge did not abuse the discretion in utilizing the standard jury instructions and not including the special instruction demanded by Taylor. In DeFilippo 255 Southern Reporter 3rd version 351, the 4th DCA was clear. If jury instructions as a whole fairly state the applicable law to the jury, the failure to give a particular instruction will not be an error. Further, in R.J. Reynolds' case out of the 1st DCA, this case tells us that to presume that standard jury instructions are accurate unless shown otherwise, which we fail which we believe that Ms. Taylor has failed to do. Agency was never pled as a cause of action. It was merely a blurb incorporated into the complaint, into the broader claims of breach of fiduciary duty and professional negligence. The jury heard testimony and considered all facts when finding that no professional negligence, nor was there a fiduciary duty owed nor breached. The jury was provided with very specific jury instructions. These instructions encompassed required elements for fiduciary duty and professional negligence. The jury instructions accurately and adequately incorporated all elements of a relationship between the parties, whether it was an agent, a representative, or a professional. It was covered. The trial court did not abuse its discretion to provide a separate, abuse its discretion in refusing to provide a separate, duplicative jury instruction on agency alone. Unless the court has further questions, I respectfully ask the court affirm the trial court's decision.
All right, counsel, thank you.
Thank you.
Mr. Frigola, you got 35 seconds on your cross-reply rebuttal here. Go ahead. No, I'm just letting him know what the time. You're up, Mr. Taylor. You're at 3:49 on your rebuttal and response to the cross-reply, cross-appeal.
May I proceed?
Yes, sir. Go ahead.
Thank you, Your Honors. Briefly, to discuss the cross-appeal on the PUD and whether this public park was optional, I think just a plain reading of the PUD shows that it wasn't optional, and then I'll get into the testimony. But the act of recreation under Article 5 of the LDC required 2.46 acres of recreation for this project. If you look at page 8 of 14, it goes on to say, however, active-based recreational park area totaling 11.26 acres containing a minimum of 8.8 acres of public recreation, this is a public park dedication, and 2.46 acres of private active-based recreation will be provided. And then it goes and talks all the amenities. But still, and then it goes down, then we get into what happens if it's not dedicated. If the public park is not dedicated, a major modification shall be required to, 1, revise the PUD map and text to remove the density bonus from the project, and 2, provide the minimum active recreation in accordance with the LDC. That's the 2.46 acres. So it was twofold. To get rid of the density bonus, you need a major modification, and to remove the public park, you needed a major modification. And how do we know that? Because Susan Conscian, the Director of Planning and Zoning for the county, testified that a major modification was going to be required to remove the park. Who also testified? Well, we had Doug Burnett's own emails dated November 3rd, 2017 in our response briefing. He writes, the PUD text says that if the density bonus is not used and the public park is not eliminated, there has to be a major modification to remove the public park. Their own agent, Rob Matthews, an engineer for Mr. Bean, he contacted the county and tried to buy out the public park because it was too expensive and cost prohibitive. That certainly doesn't sound like something's optional when you're offering to buy it out. And it goes on and on. This argument that came later, through argument before this court that this is completely optional, is just not supported anywhere in the testimony by the people that actually have authority to interpret this PUD. But the reason why that's important is because they knew immediately. That Mr. Burnett's email was November 4th, 2017. They terminated the contract November 16, 2017, because they knew that public park was encumbering that PUD and was subject to a major modification and be very costly. And for them now to suggest that Ms. Taylor did not mitigate by giving them a 30-day extension to look at zoning, which under her contract, flood zone zoning, which under her contract in the paragraph 8C, it says flood zone, buyers advised to verify by survey with the lender and with appropriate government agencies which flood zone the property is in and what restrictions apply to the improvements of the property. That was part of their contract from the very beginning. They had their own flood zone consultant saying it was moved into the new floodplain. They had Mr. Schock from the county telling them it was going to be engineered to the new floodplain, and after they push this PUD through and lock in this park through a major modification, and they suggest that Ms. Taylor failed to reasonably give a 30-day extension, like somehow that was going to change the universe of that PUD. Well, that's why I cited the case law, to your honor, that in fact failing to give a reasonable extension is not a breach of good faith and fair dealing. And so, given the circumstances that my client is, they're purely speculating, and under 768-74 subsection C, whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation or conjecture, what they thought they could have done post-breach through lawsuits and otherwise should not have gone into the mitigation analysis. Your Honors, I see my time has expired.
So what is it you're asking that we do?
Thank you. Your Honors, the request is threefold. One, that the reverse and remand with instructions that there was a breach of fiduciary duty as a matter of law, and the alternative that if the court is not inclined to do that, that you remand with instructions for a new trial on damages to give an agency instruction to the jury based upon a fiduciary duty, as well as vacate the failure to mitigate damages and provide a new trial on damages against Southeast Georgia Acquisitions.
You want us to affirm the cross appeal?
No, Your Honors. I'd like you to deny the cross appeal. I'm sorry.
He lost, right?
I'm sorry. I'd like you to affirm.
You don't want him to win on cross appeal, right?
No, I'm sorry. I misspoke. I'd like you to affirm.
There you go.
Thank you, Judge.
All right, very good. Thank you, counsel. I assume you want to win the cross appeal, right?
Yes, Your Honor.
There you go.
In my 34 seconds, obviously, the issue on cross appeal is a pure matter of law, so all of the evidence that he's pointing to is irrelevant to that consideration. The language is clear; it's optional. It's right in the PUD. As it relates to the damages, we obviously disagree about what the facts showed on that, but we've certainly shown that the jury could have concluded appropriately to show that Ms. Taylor acted unreasonably in publicly declaring her property to be worth less than $1 million or more less. And then finally, I think Mr. George's point that the damages here, if you find in our favor, render the any other aspects of the appeal moot.
So you want us to affirm on the direct appeal, and on the cross appeal, you want us to remand with any instructions, or what?
If we affirm on the main appeal, if everything is affirmed from the main appeal, the real benefit of the cross appeal is the next appeal in front of this panel, which is the issue of whether we are the prevailing party for attorney's fees, and that's a second appeal that's coming up. And if you
Oh, is there one pending with our court now?
One pending, yes,
Oh, okay.
right now. So the trial judge ruled in our favor that we were the prevailing party. Obviously, if you grant the cross appeal to find that as a matter of law there was no breach, then it eliminates that next appeal.
It eliminates his argument in round two?
Correct.
Okay, I got you.
Thank you.
All right, counsel, thank you. You made an interesting case for both sides. All right, we will stand adjourned and have a good day.